Kaparu Industries is the important case for negligence. If you look at Lord Oliver's view, he mentioned on special relationship between the maker of a statement, advisor here, which is maker, and then person relying on the statement, which is advisee, where the advice is required for purpose, whether particularly specified or generally prescribed, which is made known either actually or by inference to the advice at the time when the advice is given. So, there are some, when you talk about relationship between auditor and the person relying on auditor's information or auditor's liability, and then the advisor knows either actually or by inference that his advice will be communicated to advisee either specifically or as a member of an ascertainable class in order that it should be used by advisee for that purpose, and then it is known either actually or inferentially that advice so communicated is likely to be acted upon, okay, by the advisee, okay, without independent inquiry, and it is so acted by the advisee to his detriment. So basically, in this case, if you read further, it stated that in the case, the purpose of the auditor account prepared by auditors was to enable the shareholders as a body to exercise informed control of the company and not to enable individual shareholders to buy more shares in the company. So there was a statement made by the auditors, and it was relied by the shareholders. So court looked into the professional negligence, and they were looking into special relationship. So the auditor's statutory duty was owed to the body of the shareholders as a whole, but not individual shareholders or to the public at large. So when you wanted to determine the liability of auditor, whether they are negligent or not, you need to look at the special relationship. Remember the normal Lord Atkins principle, whereby in the case of Donahue and Stevenson, whether there's neighborhood principle, whether whatever you did or omission or failure to do effect on the end user, same thing here. They're going to ask about special relationship when we talk about professional negligence as far as auditors is concerned. Okay, and then that's all about the auditor, very brief. And then next we're going to look into meetings. Okay, the third subtopic, which is meeting. What is meeting? An assembly of people. Okay, and then in the case of Sharp and Davis, it was decided that the word meeting prima facie mean coming together more than one person. Okay, so the will of members are expressed at their meeting. So during the meeting, there will be discussion, decision, there will be argument, and then opportunity given to shareholders to question. There will also be directors to present their findings, accountant to table their papers, So these are all about meetings. And what do we need to know about meeting? Okay, they are governed by, what is it now? Okay. See, the slide is very beautiful. Okay. Okay, what is it now? Okay. Now, under Companies Act, private companies are no longer required to hold AGM in every calendar year. Okay. So, what happened here? Okay. Under Section 340, subsection 1, something here. Okay. This is different compared to the previous 1965. Previously, during the AGM, let me just show you the difference here. Let me just look a bit. Okay. Now, previously, under the 1965 Act, during the AGM, you need to declare dividend. You need to consider the accounts. You need to elect the directors. You need to appoint and fixing remuneration of auditors. This is actually the ordinary business of AGM. But remember, you have done solvency statement, right? You cannot declare dividend until directors have made a solvency statement. So now, under the current section, under the current Companies Act 2016, Section 340 provides that every public company shall hold AGM in every calendar year. Okay, and then one of the basic ordinary business that they're going to transact during the AGM is the laying of audited financial accounts and reports of directors and auditors, and then election of directors, and then appointment and fixing of fees of directors, and any resolution or other business of which notice is given in accordance with the Act. So no more declaring of dividend, no more appointment and fixing of remuneration of directors. So these are, if I point out to you, these are the important ordinary business that they should discuss. That you must discuss during the AGM. This is for public company. Okay. And then for purpose of Section 340 subsection 1, Section 340 subsection 2 provides that AGM shall be held within 6 months of the company financial year end, and not more than 15 months after the last preceding AGM. Okay, this is the requirement to hold AGM. Yeah? Okay. Now, for new companies, if you look at the middle notes, for new companies, public companies are required to hold AGM in the year of, they are not required to hold AGM in the year of incorporation, but they must have their first AGM within the 18 months from the date of their incorporation. Okay, company can apply for extension if they are not able to actually have AGM, but it's still subject to approval by the registrar. Okay, and then default in holding AGM is an offence by the company and any defaulting officer, and upon conviction shall be liable to a fine, not give, to a fine not exceeding 25,000 ringgit. It's not give, actually fine. Can you please amend the notes? Fine. Okay, Section 340, subsection 6. Let me just counter check. Okay, Section 340, yes. Okay, it's a fine. Can you please amend to a fine? Okay, now that is on the AGM. But then private companies are no longer required to have AGM. So we need to look at the meetings itself. Now, pursuant to Section 310, okay, you can have a meeting of members, okay, because they are no longer required to hold AGM. So, meetings of private companies are normally known as meeting of members. Okay, so you can convene this meeting of members by the board. The board can call out for a meeting of members, or any member holding at least 10% of the issued share capital, or a lower percentage as specified in the Constitution. So this is governed by Section 310. Okay, now okay, now meeting of members, okay, we move on further. When we talk about meeting of members, okay, we can go into Section 312, whereby directors shall call for a meeting within 14 days from the date of requisition and hold the meeting on the date not more than 28 days after the date of notice to convene meeting. Okay, so who can actually call for a meeting? Actually, members can call a meeting. They can actually require the directors to convene a meeting of members. Okay. Okay, and then section 312, subsection 4, if before that we look into section 311, okay, power to require directors to convene meeting of members. So how can you request the director to convene? This is done by requisition, to which requisition shall be in hard copy or in electronic form. And then in that notice, okay, there shall state general nature of business to be dealt with, and you may also include text of resolution, and then those requisitions shall be signed and authenticated by the person making the requisition. Okay, and then section 3.1, okay, section 3.12, it is the duty of the directors to call meetings as required by the members. And then section 3.13 says that, okay, if directors are required to call up the meeting but he did not do so, so basically the members who requested the meeting, or any of the members representing more than half of the total voting rights of all the members who requisition the meeting, may call for a meeting of members. So if the director did not do that, that particular person who holds more than half of total voting rights, they can actually call for a meeting. Okay, now perhaps you might find it that, why do we need to call up meetings? Actually, before you can, for company, before you can proceed with whatever business, there must be a resolution of the company. So this meeting is very important, so that you have enough votes to proceed with whatever projects you want to continue. Okay, and then next, this is meeting of members. Okay, the meeting of members, again, let me just stress out that it is meant for private companies, because they don't have this AGM, so they have this meeting of members and resolutions by written resolutions. Now, any reasonable expenses incurred by the members requisitioning the meeting by reasons of failure of the directors to call for the meeting shall be reimbursed by the company. Okay, section 314. Let me just check. Section 314 of the CA. It's not A, this is CA. Section 314 of the Companies Act 2016 provide that if for any reason it's impracticable to call for a meeting of members in a company, in which meeting of that company may be called, or to conduct meeting in the manner prescribed by the Constitution or the Act, the court may either on its own motion or on application of the director or member, okay, who will be entitled to vote, order a meeting to be called and held or conducted in a manner which the court thinks fit. Now, meeting of members are normally called by the members. Okay, failure of the directors to call out the meeting after being requisitioned by the members, the member themselves, as long as they have more than 1/2 vote, they can actually call out the meeting. But if it's impracticable, the court can actually intervene, and the court may order the such meeting. Now, look at this case, the National Road and Motorist Association and Parker. Members send requisition to convene a meeting. The proposed resolution purported to direct the board over some matters exclusively vested by the directors, but then directors refused. So because directors refused, the matter was referred to referred to the court. So, and then the court held that meeting convened by requisitioning members must be held not more than 3 months after the making of requisition to directors. Okay.